And there is quite a subtle, I think, relationship between the two concepts. You can't have you can't have legal privilege without confidentiality, but that does have certain implications which people don't often consider. When the client commences an action against the solicitor for professional negligence or something like that, there's very frequently a well-known implied waiver of privileged materials that are relevant to that action. Occasionally, this works in reverse, but not very often. And so unsurprisingly, the solicitors were unsuccessful in arguing that the material was not privileged. They tried to run quite a novel point on appeal by saying, well, because we acted for you as your solicitors, the material was not confidential as between us. You gave me that material, and so it was free for me to use when advising you. Since it's not confidential as between the two of us, therefore there can be no privilege over that material, and that entitles us to use it in our action against you. That was comprehensively rejected by the Court of Appeal, was that there is a difference between confidentiality and privilege. The effect of privilege is as a shield. It basically confers an enhanced degree of protection for a particular type of confidential information. So that enables the party entitled to the privilege to prevent that information from being used. But they said just because information is confidential, if that information is not privileged, that could, in some circumstances, still be admitted in evidence, even if it is wrongfully obtained by the person seeking to rely on it. I should say that that last point, I think, is slightly controversial. I'm not sure that that accurately reflects the attitude of the Singapore courts towards the use of confidential or privileged material. I do think that if confidential material is obtained and sought to be admitted in questionable circumstances before the Singapore courts, most of the time they will probably prevent that from being used.